Morning. So I'm Tom Leonard, the president of the Technology Policy Institute, and we're co-sponsoring this event with the Engelberg Center. So welcome to the arcane and fascinating world of music licensing. Kind of the origin of this project is a paper that Larry White and I wrote on music licensing, and we thought it'd be a good idea to follow it up with a conference, and I suggested to Larry that maybe it'd be a good idea to do it in New York, and he connected us all with Chris and Ann at the Engelberg Center, and the result is this conference. And I got to start out really by saying that it's really the Engelberg Center, and in particular Ann Haas, who has done all the heavy lifting for this conference. So we really appreciate that, and look forward to a great discussion.
Tom, thanks. I'm Chris Springman. I teach at NYU. I'm co-director at the Engelberg Center. I'm not going to add much except to add, again, my thanks to Ann Hassett for doing all the heavy lifting, all the logistics on this. And we appreciate you all attending. We're going to have 3 panels today in a roundtable format. It's going to be more conversational than presentations. Hopefully it'll keep moving really quickly. We're going to cover the basic landscape of music licensing, what we see as some of the workings and some of the failures in the system. We're going to talk about databases, and then we're going to talk about what can be done in the future to make this system more efficient and equitable. So thank you all, and I'm going to turn it over to Larry Miller, who's going to moderate the first panel. All right.
Thanks, Chris. And good morning, everybody. So I'm Larry Miller. I am a professor of music business at NYU Steinhardt, where I'm director of the music business program. And it's been an interesting and exciting and I think very promising year this year, following on some, I think, pretty important developments last year. As most of you know, in the music licensing study from the Copyright Office that was produced by General Counsel and Associate Register Jacqueline Charlesworth, who is here and I think is speaking on the next panel. The report synthesized in many respects the results of a period of open comments and in hearings that happened here at NYU Law School and also in Nashville and Los Angeles, and came forth with a number of recommendations, many of which we'll be talking about on this panel and the other panels that are happening today. There was broad consensus, for example, that music creators should be fairly compensated. That sounds like a reasonable and desired outcome, but also that the licensing process should be more efficient, and that market participants in general should have access to authoritative data so that they can both identify and license musical works, underlying musical compositions. And as well, that there should be put in place a system or process that would provide greater transparency in usage and payment. Now, the Office's specific recommendations, as I said, we are going to get to on this panel and throughout the conference. The report did not provide specifics, nor should it have, on exactly how to implement and prioritize that. Will be up to rights holders and music users and probably Congress and other agencies. So on this first panel, we're going to begin to unpack exactly how we are intending to do that. And what I would like to do is go down the panel and rather than have the panelists introduce themselves, if they don't mind, I'm gonna just say a couple of things about each of them. And so starting on your right, you've already heard from Chris Springman, who is a professor of law here at NYU Law School, co-director of the Engelberg Center, and is Counsel at Simpson Thacher. Chris is a noted author as well. He wrote a couple of years ago the book The Knockoff Economy, How Imitation Sparks Innovation. Sitting next to Chris is Dan Rubinfeld. Dan is also a professor of law here at the law school, and he is professor of economics emeritus at the University of California, Berkeley. His areas are primarily those related to antitrust and competition policy, law and economics, and public economics. And Dan has written several textbooks on economics and served as Deputy Assistant Attorney General for Antitrust in the Department of Justice. Next to Dan is Katie Oyama. Katie is Senior Policy Counsel for Google, where the focus is on copyright, creativity, trademark law and policy, and before that spent time in the office of Vice President Joe Biden. And before that, I believe, was in private practice. Next to Katie is Steve Marks. Steve, many of you know, is Chief of Digital Business and General Counsel for the Recording Industry Association of America, the RIAA. He is the member of this panel who I have known longest, going back to the very earliest days of digital distribution and what I like to think of as the period of responsible experiments that many of us undertook in those years. Steve led the process whereby we had a license then and now for internet radio and other services administered by Sound Exchange and many, many other laws, processes, and committees and boards that we have all been working with now for, I don't want to say how long, but I'm thinking something like 20 years, Steve, something like give or take. Next to Steve is David Levin. David is VP of Digital Licensing at BMI. Now, I knew that BMI was doing about $1 billion in collections and distributions, and the $1 billion mark by itself, not counting what ASCAP or the other PROs do, was certainly a milestone. But I did not know that BMI was the first PRO to distribute $100 million to its members on digital alone. Before joining BMI, David spent a dozen years at Sony Music. And then, at the end of our panel, we have Michael Katz. Michael is also an economist. He is a professor in the Department of Economics at the University of California, Berkeley. He has been there for a long time. Earlier in his career, he spent a bit of time in government as well, and there was a period in the 90s when Michael was chief economist for the Federal Communications Commission, the FCC. And so looking forward to hearing from everybody on the panel over the course of this next hour. Now, the foundation question that we are addressing today is, how do we structure a modern licensing ecosystem to be more competitive and work more efficiently and fairly for all stakeholders? That's it. Efficiency and fairness for all stakeholders is the topic for the day. And so the first question that we're going to address is, what are the necessary and sufficient components of a well-functioning and competitive music licensing market? And as a way to begin to address the question, Dan will provide an update.
Thanks, Larry. Any comments I give this morning, by the way, represent my own opinions and not any opinions of anyone I've done work for in the industry. I just want to set the stage by talking about some of the rapid changes we've seen in the industry, which I think make it difficult to answer the questions that Larry put forward. And I'll do that very quickly. So not only have we had a kind of rapid move towards growth of the digital side of the business, while that has happened, there has been, in my view, functional convergence between statutory and on-demand services. I would give you as an illustration the fact that if you happen to be a Pandora user, if you work hard at it, you can actually get to play the song you really want. It takes a little bit of effort, but you can do it if the song is part of their portfolio. And of course, Pandora does occasionally feature specific songs with its premieres option. On the other hand, if you're a Spotify user, where you do get to pick your songs, you can actually create stations in a way that's very similar to what Pandora can do. So those two examples illustrate the kind of functional convergence I'm talking about, which I expect to continue over time, making it a little difficult to think that we'll stay in a world where the CRB is regulating certain forms of services and not others. Along with that perhaps controversial description, streaming has obviously gotten more important. It's over 25% of music industry revenues now, and the expectation by most people is it'll be in the 50% range before this decade is over. On the services side, the world has gotten very competitive, particularly on the digital side, with companies like iHeart moving into serious webcasting, and of course Apple jumping into the fray with a new product, just as one example. On the label side, everyone knows that there's substantial concentration among the big three labels, but what I see as significant is the growth and importance of the role of the indies in signing new artists and selling their talent and their services. And I think the relationship between the indies and the majors is somewhat complex because of the distribution side, but I think the indies are going to continue to play a greater and greater role in the industry. Now, in terms of royalty rates, rates have generally been increasing. From the point of view of the labels, they're still very low, but they have been increasing. And from the point of view of the services, that's a substantial cost because it's a significant part of their business. On the other hand, what's unusual about the industry is that the significant constraints come from some of the statutory history of the past, free terrestrial, the fact that YouTube generally is offering music which is not paying royalties, and of course the constraint from piracy, which is something that the industry has had a lot of difficulty controlling and probably still will continue to have difficulty with as the years go by. Finally, more and more royalty arrangements, at least the ones I'm aware of, have been negotiated in the statute of the statutory rates or in the statute of the consent decree with DOJ. And so when you have a world that more and more negotiations depend on the statutory overlay, that raises interesting questions about how the statutes and the consent decree should evolve to reflect all the changes I've described. So I will stop there and leave the answers to what this all means to the rest of the panel.
So do we have the building blocks even in place to have a fair music licensing market? Is the market already fair?
So the word fair is really tricky because in a market, in a competitive market, we kind of get fairness as the result of market transactions, right? Arm's length transactions between willing buyers, willing sellers, prices get set, trades get made, and I think we have a consensus that in every case those may not be desirable, but they're on the whole and over time fair, right? That's what we're committed to as a market economy. When we don't have a market that's well functioning, it's difficult to define fairness according to some external criterion, right? So the streaming services will say, well, a huge part of our revenue goes to paying licenses. And the owners of musical compositions will say, well, why are we getting compensated differently than the owners of copyrights and sound recordings, right? So there's a different regime here. There's a lot of fairness points that people make. It's very difficult to kind of stand above this, as a kind of neutral arbiter and say, well, here's the fair result. I think the key question would be, could we get to a place where we could depend on the market to produce fairness, rather than legal decision makers or market participants arguing about fairness?
Yeah, I would answer, Larry, your question, no. We don't have the right system in place, and I think that's because we have a number of what I would term government-sanctioned subsidies that exist across the industry. So if you look at either the safe harbors of the DMCA, if you look at exemptions for things like terrestrial radio, if you look at rate standards that are by definition below market rate standards like Sirius enjoys, if you look at the kind of convergence that exists that Dan was talking about, where some of those services are availing themselves of the statutory license and others are not able to, all of those things are interfering and indeed distorting, I think, what we would think is a fair market. And I think if you drill down into each of those, you can see how that's happening and actually the money that's being lost, at least on the creator side, in the billions of dollars. And I don't think you can look at any of them in isolation because there's kind of a knock-on effect. If, for example, I am a company like Spotify or some competitor of a company like YouTube or a competitor of Pandora's, and they're operating under one of these government-sanctioned subsidies, in essence, I'm going to ask for rates. I mean, I cannot compete in the same way or that they can. So when I'm in a negotiation with a rights holder, the first thing that I'm going to bring up is, well, wait a second. I'm offering essentially the same service that YouTube is offering, yet they're only paying X. So in order for me to compete, I need to, I can't pay this rate or I can't pay that rate or I need to do, X or Y. Same thing with, Sirius X, even in the context of some of these government proceedings like the CRBs, Sirius in the first few proceedings came in and said, hey, we compete with terrestrial radio and they pay zero. And then you have Sirius itself getting the advantage of a below market rate standard where they're paying in essence half of what the CRB had identified as the rate. And then you have other services saying, well, wait, if they're only paying half, why should I be paying this? And so on and so on. And so you have this knock-on effect. And if you just look at some of the numbers, I mean, obviously there's been a lot of focus about YouTube and some of the numbers around that. And I'll just repeat a couple that Katie's heard 1 million times, but maybe those in the audience have only heard 500,000 times.
Katie, you'll have your turn.
I mean, worldwide for safe harbors, which YouTube is a big part of, you have 900 million people generating for the industry $630 million, so roughly 67 cents a year. You have terrestrial radio, which has more than 200 million people listening to it, generating nothing for the sound recording copyright. You have in the safe harbors, as was mentioned, not only the YouTube issues, but the piracy issues. There's no greater example, I think, than the decision that came out yesterday in the Vimeo case, where the court essentially said, even though the facts in the case were that the company essentially had a policy to look the other way, it read the statute as saying, sorry, the safe harbor provides immunity for that activity. A lot of people like to bring up, well, Groove Shark, that's a company that's down now and everything else, but it took years and years of litigation to get to that point because they were able to rely on the safe harbor. So all of these things, and then you look at Sirius in terms of the actual dollars, it's hundreds of millions of dollars a year, the difference. So when you add all these things up, and then if somebody a lot smarter than me in economics were to try and figure out what the knock-on effect is and what it would be, you're I think, safely in the billions of dollars that's being lost for the industry as a result of these distortions.
Right. So, Michael, I want to ask you about the knock-on effect in just a second. But first, let's hear from Katie as the sole music user on this panel.
I don't know about that, but
I use music.
no, I also just wanted to start by saying thanks so much for convening this conversation. I actually live in DC now, but I grew up in Greenwich Village in an artist residence just a couple minutes from here, and many different performing artists, and I think it's very encouraging to see discussions like this where people from various backgrounds are coming together to talk constructively about some of these challenges. I think it's probably fair to say if any of us were sitting down today to construct a system, it wouldn't look like the one we have today, right? It's very fragmented, very opaque, and legislation has been tacked on over time as new ways of distribution were created. So it doesn't surprise me that people on many different sides feel some sense of unfairness. So when, Steve says there's a government-sanctioned subsidy, for every person that says that, there'll be someone that says there's a government-sanctioned monopoly and I'm trying to license music and pay for music. I'm asked to pay for something and I don't even know what it is that I'm licensing because there's no information that exists in a comprehensive way. So I think maybe one good question to think about is, how do we make the system more fair for everyone? And there's a couple places where I think you have some consensus coalescing. One would be transparency, so that all people looking from all different perspectives are looking at the same information. So on rights ownership, because of the way the copyright system has evolved, there is no single, authoritative, comprehensive, accurate place where someone that wants to license music and pay for music can go and know who to pay. There is, I think, a lot of confusion about how much should be paid on various different regimes. There's not a lot of transparency about how money flows. So just for YouTube alone, we have paid out more than $3 billion to the music industry. When we send out royalties for a 90-second piece of music, because of the fragmentation in the market, often that gets split into a large number of different places. I can understand from anyone in that stream the desire to have more transparency about how the money is flowing. I do think there's some very encouraging pieces. So things like the safe harbors increase competition in the market. It is extremely difficult, challenging business to run a digital music service. You have statutory damages. You have a lot of risks involved in launching something like that. So the safe harbors in the United States not only are essential and critical to the entire internet economy, including other sectors of the market. I think any startup or entrepreneur or venture capitalist will tell you that eroding the legal foundation on which our entire sector, for which we've become kind of the envy of the world, would be devastating to all sectors. But you're seeing incentives for many different types of innovations. So not one method of delivery is the right size to fit all. I think it's great that we have subscription, ad-supported, streaming models, download models, many different ways that users can access content. But you want to look at policies that would encourage more competition. And one of the things that we've seen on YouTube is brand new revenue streams emerging. So today, the Content ID revenue that gets sent out from our system that runs underneath YouTube, 50% of that revenue is actually coming from content that users have uploaded. So artists can launch an initial song on the channel that they're monetizing, but today, an entire market that used to be considered unlicensed or piracy, that wasn't pre-authorized, because we now have databases that can connect rights holders to users, there's a way that not only can the user upload this content, and sometimes those are the pieces of clips that are the ones going viral, but that underlying rights holders actually get to participate in that and do very well. So there's many, many examples of songs where the revenue from the user-generated content has actually, exceeded the initial one, and that's actually very exciting and part of the way that music is going viral today, especially amongst young people. I think services like YouTube are one great model. You have services like Spotify and Pandora that are exclusively music, and they're going to have a certain way of being. You have something like YouTube where, on average, our users probably listen to music for about an hour a month, so we'd like to get that number higher, but you are receiving access, if you're an artist, to a global marketplace, and there's many different examples of people who didn't have many resources, uploaded something from home and have gone completely viral and have become international celebrities and, household names.
Well, Larry, I'd just like to comment on one thing that Katie said, and I don't want to monopolize the conversation, so I'll keep it short. And going back to your comment about being around 20 summer years or so, that includes the time that the DMCA was passed. And Katie was saying that the safe harbors are essential for the creation of music services. That was not what I recall being the essence of what the conversation was. The conversation there was not about creating a music service. It was about internet services, like broadband services, for example, that had music flowing through their pipes, et cetera, that there needed to be some balance. When you're creating a music service, just like Spotify created a music service, or Apple's created a music service, or any of the other services, it's very easy to go create that, go into the market, and get the licenses that you need. So I don't think the safe harbors are necessary to create a music service. I think you can,
Well, it can't be easy.
Yeah.
Spotify's being sued
And it took years to launch. I think
by
easy is.
dozens of people for failure to match music composition licenses to sound recording licenses. So
Yeah.
it's certainly possible. But
Yeah, at least we know there's a path to
We
getting a
sh- we
license,
sh- we-
right?
Yes,
I'm not sure how
I
easy it
agree
is.
that the data issue is something that is a very big challenge for everybody in the industry that needs to be addressed, no question about it.
So, Michael, before we get too far afield, and of course we run some risk of going down a long dark alley in kind of relitigating the safe harbor here on this panel, but at the risk of doing that, I want to ask you that original question about the building blocks for a fair and equitable and competitive music licensing system in this country.
Well, I'm going to give a rather shorter answer than we've been hearing. And that is, if you want a competitive market, you need competition. And I don't think we have it. I think if you look at a lot of what goes on in the industry, I would say the structure of the industry is not conducive to competition. And oddly, I think it's simultaneously too concentrated and too fragmented to do that. On the concentration side, we have it with the recording companies where they are not competing. And I'm not saying they're colluding. I'm saying given the structure of it, that if you look at their sales to interactive service, right, the FTC has found that they're offering complements. You have an oligopoly of complements, which economists have known for hundreds of years, and it's now being proved today, is actually less competitive than having a monopoly. Now, what do I mean by it's too fragmented? And of course, there are other things where it's too concentrated for competition, such as the PROs. Too fragmented, if you thought about sort of designing economic institutions, and I now mean the market institutions, not the regulatory ones, I don't think you would come up with a system where you would sell the rights to the, you would not separately pay the people composing the songs from the people performing them, right? You wouldn't think about this if you're selling shoes. You would think it's very odd if you had to buy left shoes and right shoes from separate companies, and where some of you may have more of a fashion sense than I do, so because I would wear unmatching shoes. But if everybody had to wear matching shoes, right, you'd have this problem because they're complements, and once you bought one of them, you're stuck. You got to only go to the only supplier of the other. You wouldn't buy them that way. You'd say, well, let them work it out with each other, and I'll buy it from them as a bundle. So I think it's a peculiar organization we have, industrial organization, that you can't just go buy one right and then use it. Let me just say a couple of things about convergence, since I wonder if I ever get a chance to speak again. My problem is I'm very literal-minded. When I was told we were not supposed to have 5-minute openings, I thought we weren't supposed to have 5-minute openings. But on convergence, I think Dan has overstated it to a degree, but I agree that there is sort of broad convergence. And more importantly, it's an odd situation. I think this is probably one of the few things everyone will agree on. You start having product design decisions driven by the regulatory structure. And you start having to ask yourself, if I want to offer an innovative new service that I think consumers are really going to like, what is that going to look like to the copyright licensing regime? And if I add this feature, is that suddenly going to flip me from one category to another with potentially very large consequences for what I pay? And again, that's just not a good situation. So I do agree that we need to think about some way that these boundaries are not driving everything. Of course, the most extreme form, there are two ways to do that, and one is regulate the bejesus out of everything, and the other is to deregulate it all. And don't think we're going to see either of those, but I mean, that's definitely that's always a problem with leveling the playing field, is which way are you leveling it? And I'll stop there.
Well, so one of the ways that we try and teach our students, and our grad students in particular, how to think about inventing the future of the music business is by studying other industries with different kinds of regimes and observing the best practices from those industries and looking where we might be able to apply them in the one that we care about so much, the music industry. So I wonder if there are any economic models for Dan and Michael in particular that we should observe from other industries that we may want to consider in this overall discussion of copyright revision and putting in place a more equitable music licensing ecosystem.
You're looking at the only other economist on the panel. That's a really hard question, so I'm not sure I have, I can explain to you why it's a hard question, but I'm not sure I have a good answer for you. So let me start there. What makes the kind of debate that Michael and I were maybe starting to have here difficult is that licenses are driven by, in the current world, more and more by negotiations and not by the statute directly. There's so many folks that are not directly covered by the statute. And so in order to understand the workings of the market, we need to understand the nature of these negotiations. And they're complicated for reasons most people in the audience know. And it's true in that world, it may be that on the one side there's bargaining power on the part of the labels and the artists because the stations and the services need the music. On the other hand, the artists and the labels are not going to make any money unless their music is played. So there's also bargaining power on the part of the services. And so in order to think about regime change, we have to first understand the nature of these bargains, not so much understanding every detailed contract, but the nature of the power on both sides of the parties when these deals are negotiated, and then to figure out how that translates downstream to the users, to the ultimate consumers of music, and then figure out how a change in some of the structure that we talked about, a change in the exemptions and so on, would change the nature of this bargaining situation. And it's a little hard for me to think about how to work that out because the current structure we have is largely in place, and even some significant statutory changes I don't think are going to change the structure very much, which means that the kind of discussion that Michael and I might have offline is going to be continuing for years to come.
Can I propose an industry that could be a model, but it's like a really, really bad one, and that's the cable television industry. So there you have oligopolist complementary programmers, right, that package license programming. And on the other side of the table, you have distributors with significant market power. So you have cable companies, satellite distribution companies. Right now, that market's in flux too, but this is what you've had traditionally. So you have negotiations that have bilateral market power, and it's hard to model where those land, but where they've tended to land traditionally is you get fights and you get withdrawals by the programmers, and these fights eventually get settled. And the way they get settled is the cable companies extract more rents from consumers, and they decide how to divide it up, and you get a kind of upward spiral in prices, which outpaces inflation by a significant amount. So that's a model. And how would we get there? I think we would get there if we removed regulation with the current market structure that we have. I think we might get something like that. Now, you could say that the music industry is constrained by piracy, so Spotify can't raise its rates too much, or people start pirating who were previously consuming from Spotify. I agree, that's true. There's some constraint from piracy. I mean, the television and movie industry is also constrained by piracy. If Comcast raises the rates too much, people start pirating. People start cutting cords. So on the edge, there's always a constraint from piracy. I'm not sure how powerful that constraint is and how much it would restrain the parties from basically extracting rents and dividing the rents among them. So that's a model. I'm not enthusiastic about it.
David?
All this, has got me thinking just, why is music so special that music needs to be regulated? When you look at other IP content, whether it's a cable, whether it's, film, why does music need to be regulated? And I don't, I hear a lot of different pieces here. Katie talks about, monopolistic power and government control monopolies, where Steve's talking about these government-controlled subsidies. What is it that requires music to be regulated? I wouldn't say that government's controlling government is not controlling the monopolies. These monopolies exist. Yes, Michael mentions the PROs at BMI having market power. We're looking at changing that. We're having an active conversation with the Department of Justice. One of the things is very pro-competitive, allowing the publishers to withdraw and to go and license their rights directly. This is getting pushback from licensors who want to keep this monopoly. It's almost a hypocrisy that the monopoly has too much power, but we don't want to break up the monopoly. So where does the monopoly exist? Does the monopoly exist in a couple of large societies that bundle in rights, or does the monopoly exist in whether it's a cable provider that a cable network needs, whether it's a large music label that a music service needs? I think these are the kinds of questions that we need to think about, and how is this market really working efficiently? Could it work more efficiently if the players were allowed to negotiate more freely without this government interaction?
Right. So since you met, well, Katie, you have a comment, and then I want to talk about the consent decrees for just a minute.
Oh, sure. I was just going to mention, I think one of the interesting things that I've experienced being at Google is kind of an up-close experience with almost every different type of licensing model there is because of the variety of products. So, the vast majority of music partnerships are the direct license deals. There are also new technologies and new companies that have been acquired that very much relied upon the statutory regimes. Those smaller companies did not have the team of lawyers that we've had, for example, at Google Play. We're very excited now that we have licensed music in more than 60 different countries. But the number of hours that has taken to go segment by segment and country by country has led to a lag in the time to be able to deliver these licensed services to users. So when we're thinking about markets, I think one interesting perspective would be not just to stay constrained within the market as defined today, but to think about how do you expand the market. And one place for the music sector definitely is to look beyond the United States and to think about how can we build systems and licensing structures here that will actually scale globally. You have a limited number of users ultimately. There's many more I think that can come into the fold, but at a certain point you're going to become saturated. But if you look globally, there are more than 2 billion people that are expected to come online only in the next 2 years, only on mobile. So that's just a tremendous opportunity, I think, probably for everyone on the business side that's sitting at this table, and to really think about how can you more quickly and efficiently scale those models to reach the users, to generate more revenue, back to all the various rights holders and platforms would be a constructive way to go. I think sometimes it becomes very narrow into these fights over very specific, minute, royalty pieces that can kind of poison the well on the places where there's more in common.
So in order to mitigate that gap between, just that licensing time lag that exists in building a new music service, should there be a compulsory license for on-demand music streaming?
Are you asking me?
Yeah.
At Google, definitely between Play and YouTube, the vast majority of our licensing, is the direct piece. I think there's other services that are wholly reliant on the statutory structure, so we haven't been, as involved in some of these conversations. I think we do see in the market, that having this system as a backdrop is very important and very necessary. Some of the problems that exist when you would have even more fragmentation is incentives for holdouts. So if a service wants to launch and has licensed 99% of the market, it gives extreme power to that last 1%, and we have seen examples where that last person who has held out can hold up an entire service, and it really creates some distorted incentives. So for the benefit of getting services to market, getting more revenue in the hands of rights holders, and getting more music delivery to users, I can see holistically how this is a good option to have. You know, we are excited that I think some of our products have gone beyond those structures, and are very, you know, happy about many of the direct partnerships that we have with all the major labels, publishers, many different independent artists that are also using the services to go direct to the users.
Steve?
Yeah, I would say no to that. I think that more government regulation is not the answer, and I think we need to differentiate between making a industry more efficient and solving, for example, some of the data issues that I know will be explored on the next panel, and just having expedience, doing something for, you know, expedient just for the sake of having something faster that is not in the interest of the long-term health of the industry. I mean, yeah, as I was going through before, all of the things that tend to depress rates, if you're just adding more onto that, yeah, maybe faster for, or easier for a service to get up and, you know, more quickly. But at the end of the day, if there's not enough money flowing into the industry, to the creators of it, that's not good for the services or the industry.
Keep in mind that the choice between free market negotiations and some form of compulsory license is often dependent on how inefficient the market is, right? So if the data problems are as bad as they are in the music industry, that's an argument for compulsory licensing. So, you know, two things can happen. One is a lot of those data problems can be solved, right? They can be straightened out. I would observe that we've been experiencing these data problems for a long time. They have not been solved, right? So that the music industry hasn't yet marshaled the resources to solve them. I think, you know, we should take a shot at that and see what happens. The Copyright Office has given a lot of really helpful, I think, guidance as to what we want to look at and this first steps to take to do it. But the compulsory licenses are there in case you can't. I think that's to a certain extent, that's the sword that's hanging over the entire process.
And we don't have want for competition. You know, there's an active, robust market. We have a number of different players competing with different services out here. The market enables that with this balance of negotiation and some regulation. And I don't mean, I know you're asking about the consent decree before, and I can just touch on that briefly.
We will get there in a minute.
Yeah, but we're not, you
continue,
know, we're
please.
not looking to completely deregulate the industry. I think it's just a question of how much regulation is needed to enable the competition that we have, to enable free market. And when we look at it, where is that regulation and how deep does that go? And who is it really benefiting? Is it benefiting the rights holder, the content creator, or is it benefiting the user of it? It needs to benefit both, but it seems right now it's a little lopsided.
Right, so on this issue of licensing and new service development that we've been exploring here for a couple of minutes, actually Dan in his opening remarks talked about the hybridization, if you will, of, you know, digital music services. Most of you are aware that Pandora, for example, the leading non-interactive service, has announced plans to develop or offer one as early as the second half of this year.
Offer an
Interactive service, right. And there are elements of Spotify's service, and certainly Apple Music and other players, that are kind of offering a hybridized service, or at least promising to do so. And I wonder, how should we license those? Should they be negotiated? Well, they must be negotiated within the context of the laws and processes and regimes that we have today. But thinking about the way the world is evolving, should there be a simpler, less friction-producing way to be able to license a hybrid service?
I think one of the problems that we have faced is that the statutory license in 114 for sound recordings is far afield from where we all thought it was going to be when we sat down and talked about it back in 95 and then again in 97. I mean, it was about radio-like services. something not exactly like terrestrial, but similar to terrestrial, not the kind of customized services and the other kinds of functionality that you're talking about, where Pandora looks a lot like Spotify and Spotify looks a lot like Pandora. And so I think we all have to be realistic that it'd be great to move to something with a lot less government regulation, or to move to a different model like Chris was talking about, to see how that works. But we have to work with what we've got and try and carve away the things that are making it very bad. And so I think there are things you could do with respect to the statutory license, the safe harbors, and some of the exemptions at least, to address those kinds of things without taking the whole thing apart and having, for example, chaos on the side where you've got all the data issues, for example, that exist.
Katie, do you have a comment on this hybridized service licensing question?
I think in the market, the variety of models has been a positive thing for the music industry and for the users. You've seen different trends, and one thing that we've definitely experienced, especially with young people who are consuming music, is there are many, many different ways I think that are appropriate to them. I think the movement to the cloud is a huge benefit. You can now access your music from anywhere, and that's a relatively new development. It is still incredibly hard to enter into this market, and I do think competition is hugely important. If you're a music rights holder and you're just negotiating against one or two entities, generally that's going to be a much weaker position. And so looking at policy from the perspective of what would encourage more services and more types of models is going to be, I think, very important. On the user side, another, I think, really interesting trend has just been the increase towards personalization. So that, I think, makes the music experience just very compelling to users, that you can be delivered a playlist every Monday morning that tailored to your interests. Or what we've been experimenting quite a lot on the different models is knowing where users are, how can we deliver licensed content to them quickly and easily. So on things like search, we've worked with partners to embed different types of icons, and now because the phones are so smart, they can tell, are you a Spotify user, are you an iTunes user, are you a Play user? So if you did a search for a certain artist that you're interested in, not only would you get the Wikipedia page or their main website, but you'd also actually get like a one-click option to get into the stores to purchase the music.
Okay, fair enough.
So if I could jump in, I have a comment and a question. The comment is, in any world like the one we're in, where we have a statutory overlay, negotiations over particular contracts are going to be in the shadow of that overlay, whether you're operating as a statutory service or not. But there's a flip side, which is the CRB and perhaps the Justice Department as well, in thinking about how to make the system operational, are looking for evidence from the market, which is evidence based on deals negotiated in the shadow of the existing statute. So there's a certain circularity that's inevitable in this business, which means that the best way, perhaps ideally, to think about a structural change is to imagine an experiment where we have a very different statutory overlay. And I guess my question is, are there any examples, I'm not sure I have any, outside the US where there's a different system which might give us some learning about what would happen if we were to make some changes in the current statutory overlay?
Anyone?
Well, I can't think of any myself.
Okay.
Next panel.
But before the next panel, I do want to spend a few minutes exploring the consent decrees. As I think we all know, the consent decrees that govern, or maybe I should say constrain, how ASCAP and BMI operate are under review now by the Department of Justice. And so, David, maybe you can update us on the consent decree review process, and we have a couple of questions about that.
Sure. Well, there were three main components in our conversations with the Department of Justice, one of which we already touched on, was to enable more competition in the marketplace, to enable publishers to withdraw certain rights if they sought to do so. So we think that's a very pro-competitive move that enables that takes really away this monopolistic power from BMI, if you will, by reducing what we have the rights to license and enabling more players in the marketplace, which we think is a very positive.
Why would you be in favor of that?
I think it's important that the publishers have the ability to license their rights as they see fit. BMI doesn't own any rights. BMI, right, for those, I think everyone here probably knows, but if you think about it, we don't really own the rights. We are just the agent of those rights holders. And if those rights holders believe that they could license their rights for whatever reason in the marketplace more efficiently, obviously they've said that, under getting away from the government regulation, they believe that they could, and they've proven that they can get, rates that they feel are more representative of their repertoire and how it's being used, then they should be able to do that. And that reduces BMI's power. That I think is a positive for everybody here and what we're talking about in creating a more fair, open marketplace. So that's one of the things that is part of the discussion. Another one is what we were talking about before, the ease of access. It's a difficult right marketplace. You have to get your performing rights, you have to get your mechanical rights, your sound recording rights. We've talked to the Department of Justice enabling us to bundle rights, to bundle both the the performing right and the mechanical right into one. Only if the marketplace wants to purchase those rights from a society, and only if the publishers want to offer those rights. So again, we're not putting anything out there that the market wouldn't want and wouldn't be pro-competitive for the marketplace. And the final thing is the rate court process itself. A federal trial seems is a very expensive, long process to solve.
Can you just talk about why there is a rate court structure in place and when it gets turned on?
Well, yeah, it's interesting because the rate courts are really in place to settle rate disputes. That's why it's called the rate court. In practice, they've done more than settle rate disputes because there hasn't really been significant decree reform in quite some time. And so things like partial withdrawal, the courts have opined on and have come up in trials, specifically in the Pandora trials that both BMI and ASCAP had. But they're really there to kind of interpret, they're there to set a rate. What they've been doing is interpreting the decree in lieu of reform. So that's what the rate court's are really there for. As such, just to settle a rate dispute, which is, again, what they're intended for, a federal trial is a pretty excessive, expensive, long process. And it adds a complexity where for both sides, because either side can take the party to the rate court, it adds a complexity to it where you're starting to make a return on investment consideration, where you have to maybe negotiate, you have this government regulation, but now the government regulation is really prohibiting you from doing a fair market negotiation because you have this rate court that's a costly, long process that may not be worth going to for. So what we've asked for as well is to move to an arbitration model in lieu of the rate court.
Right, and Chris, I have a question for you about rate court in just a second. I wonder, David, if you have a comment about the efficacy or desirability, and Chris, please join in on this as well, of a process where we have two separate rate courts for two separate PROs that in many ways compete, where the judges, who are essentially appointed for life, are able to reach opposing conclusions on basically the identical case, the same case as we saw in Pandora last year.
Yeah, it's not pretty, but I just want to, I think that's focusing on the wrong thing. So I started thinking about the consent decrees a decade and a half ago when I was at the Justice Department. I'm not speaking for anyone at the Justice Department except, my own thinking at the time and how it's evolved. I think there were a lot of things that have developed in ways that the Justice Department didn't anticipate. So the genius of the consent decrees is that you take a price fixing arrangement, which is what the PROs are under antitrust law, and you recognize the potential pro-competitive benefits from the price fixing arrangement, which are one-stop shopping for licensing. So this is a pretty simple model that the Justice Department had in mind. And so this isn't regulation. This is the blessing of what otherwise would be a price fixing conspiracy. Okay, so it's the failure to apply antitrust, not the application of antitrust. It's the holding in abeyance of antitrust because of the pro-competitive Now, what the Justice Department did was they set up a bunch of requirements that the participants in the PRO had to live by, right, in order to take advantage of the immunity from antitrust. One of them, for example, was they couldn't exclusively license. Now, ASCAP just got fined 170 some odd million bucks for failing to respect that. Okay, but there's some rules. I think the way things have turned out is very different than what the Justice Department had in mind. So the Justice Department had in mind that the PROs would compete with one another. I think, as Michael said, they don't. They are complementary oligopolists, meaning that from the perspective of Spotify, it's not like you have ASCAP and BMI competing to license. You need the licenses from both, right? They're complements, not, for most purposes,
But they're
competitors.
we're competing on rates, no?
No, I don't think so. I think you're
can tell you we
selling
are.
different products, and at the end of the day, Spotify has to have them both, and they're not effective competition for one another. Here's another thing that the Justice Department didn't anticipate that has happened. So the Justice Department thought, based on what ASCAP and BMI say to the public, that if you license their repertoire, you get to play their repertoire. That turns out not to be true because the PROs own, for a lot of their repertoire, fractional shares of the repertoire. And so you can't, and this is another reason why they don't compete effectively, you can't just license from ASCAP. You've got to also license from BMI and CSAC in order to be covered if you're a significant service. So these are complements, they're not competitors. This is an enormous prop that kind of supported the logic of the consent decrees that I think the PROs, without intending to, have kicked out in their representations to the Justice Department recently. And it'll be really interesting to see what the Justice Department does. I mean, my prediction, for what it's worth, is that they're going to be frozen because it's a huge problem that they've backed themselves into. It's very difficult to go ahead and back yourself out. But the idea that partial withdrawal is competition, I think is debatable, right? So to me, what partial withdrawal represents is partial withdrawal so that complementary oligopolists can exercise the full measure of their complementary oligopoly power against distributors. Notice that ASCAP, BMI, CSAC, the Sound Exchange, they're going to continue to represent the music publishers for rights to, the terrestrial world, the analog world, right, where there is no desire to withdraw. It's just where, you could really exercise the full strength of your oligopoly power that they want to withdraw. And, the PROs are frightened to death of the participants just withdrawing altogether. And so they are doing, I think, the best they can in a tough situation, but I can't imagine any of this working out very well in the end. So it's a problem from hell.
Chris, you were just alluding to some of the problems that arise as a result of split compositions, right? Now, as part of the review of the consent decrees, DOJ has raised the issue of 100% licensing, and I wonder, David, maybe you can define what that is,
Sure.
and then we can talk about 100% licensing.
So that's the concept where, and there's probably others who can better define it than I could up here, but I'll do my best. That's the concept where any holder of any percentage of a right can license the entirety of the work, can license the rest of the work that they don't control, just by virtue of them having a portion of the right to license. This is not how the market works. This is not how the market has ever worked. Not from a sell side or from a buy side. It's always been on a fractional basis where pricing, use, requests have always been where the users recognize and price based upon their different pieces. Now, I was mentioned before the ability for, I think Katie mentioned the ability for a small rights holder to wield power, and this is kind of the one argument where you say, well, maybe this doesn't make sense. Maybe there should be 100% licensing. But I don't think we've really seen that in the marketplace where, again, for, in BMI's history, 75 years, we've been licensing based on a fractional basis. We haven't seen this kind of holdout where it's really prevented somebody from licensing these rights. So this is the market, how it works today. I think if you force this 100% licensing, as the conversations with the Justice Department have talked about, you really get to a place where you're really getting into the creative process, because now you have writers who are going to say, well, I don't want to write with someone else who is represented by a different society, because now they're going to go ahead and they have the ability to license my right. It strips that creator of some of their rights by giving those rights away to somebody else that they've collaborated with.
That is the copyright rule. So the default rule in copyright is that if I'm a co-owner of the work, I can license it and account to you. This idea that fractional licensing was the rule was a huge surprise to the Justice Department, which ended up issuing a request for comments on precisely this issue, because when they heard it, they thought, whoa, that's a surprise to us. So I don't know, there was a lack of communication. I don't know who's to blame for it, probably blame is spread around, but there was a lack of communication.
I don't know if it's communication or just the way the market has effectively operated. Everyone understood that you licensed the portions, that there were multiple rights, and I think kind of trying to put it back into a box at this point really, it gets into the creative process in a way I don't think anyone intends to.
There is also, another model, which is instead of having songwriters belong to the PROs, you would have songs belong to them. And then you could just always have any one song went to one place, and this would go away. And then if you have multiple writers, they could decide among themselves which PRO represents that song, and you would just allow the market to function. So again, I think we've got to remember there's a lot of regulatory overlays, but there are also a lot of particular market institutions that I think we need to think through as well and what they're doing.
I think it's also important not to kind of assume the existence of perfect information when today I think everyone has realized, that that's very, very far from the case. And so if any publisher were to withdraw, being able to say with certainty, this is actually what's in my catalog, this is what's being withdrawn is, going to be really essential. I think if you look at the breadth of stakeholders who have weighed in, it's quite interesting. All the different types of entities that we may not think about that can actually license music. So from hotels to restaurants, there's the bars. I've been surprised at how many different types of entities have weighed in to say, we don't have the resources actually to, it may sound very appealing, this kind of freedom to negotiate, but the practical effect would be a real halt in the ability to do these licenses and to pay for the music that is inevitably, going to be played at all of these different venues.
Yeah, I think Katie's right that this is a data issue, and there's a little bit of the tail wagging the dog here. We're trying to solve the data issue through, changes to the consent decree and the way things are licensed. But if we could solve the data issue, then a lot of those problems would go away, and it would free up creators to license the way you would normally license in any other market. And the main problem, the sound recording side is not perfect, but I think we've all been kind of alluding on the panel to the fact that on the composition side, especially due to the splits that are often take place, especially in hip hop or pop songs, where you've got 10 or 15 writers and the splits aren't figured out in advance of the release of the record, and nobody wants to hold up the release because it's got to get out there, especially in a day where things leak and can get consumed, and then there's no commercial value at all. But there's no authoritative database of ownership on the composition side. And if there were, that would go a long way to solving a lot of these problems. And instead of having to layer more regulation to address what is essentially a data problem, solving that data problem itself would solve a lot of the licensing issues that we've been talking about, and I think make some of these debates go away.
At the risk of preempting the next panel, I just want to ask our panelists, if anybody has a point of view on exactly why that is the case. Why do we live in a world in almost 2017 where there still isn't an authoritative, transparent, open data set for underlying musical compositions and sound recordings?
I think there are a lot of reasons, but I think one reason is if you look back historically at how music has been made available and consumed, to get to something Chris said earlier, it was essentially a product where all the rights were bundled. You went to a record store and you bought an album, and you weren't having to get, part of the album from one place and part of the album from the other. All the rights were generally cleared by, the record label. Now, were all the splits always figured out? No. Was there, follow-on work to be done? Was there money that was left to be figured out at some point later? Yes. But in a world where you had a healthy industry, where there were a lot of advances that record labels, for example, were able to make because they were in a much healthier music economy, a lot of times there wasn't the incentive to go back and figure out some of those splits, because it didn't matter. A lot of the people were already getting paid. And a lot of the music, the music has changed as well over time, where, the bands that wrote their own songs, it was easier to do that. Now you shift to a model where there are services that need to get the rights in order to offer those, and they need to get them from two places. Now, that in and of itself was something of a controversy back in 2000 about whether a stream requires a mechanical or whether it doesn't, and we worked hard with others in the industry to try and solve that issue so that we could just get these darn services out there to consumers rather than wait on it. And initially, labels were offering the licenses on what's called a pass-through basis. So they would, offer along with the publishing the licenses and all the rights. That changed over time in large part because the complexity of the data and the economics of the business made that very difficult for labels, and so some hard decisions had to be made about whether that was the right way for, if you're a particular label, to do that. And so you ended up with having to go to two different places, which is a bit of an oddity when you look at other markets and you have a consumer or a distributor buying one package.
If there was something on the publishing side that was as advanced as Sound Exchange on the recording side, I think we'd be in better shape.
Yeah.
That's always a question that I've had, is why was the world changed, and the record labels had Sound Exchange and they've worked with Sound Exchange. It's not perfect, but it's best. It's the best thing that we've got, right? So what's the impediment on the publisher side?
I think it's a little bit of a twofold. One piece is expertise. So, one of the things that we're very good at Google is managing information. And I'd say at this point with Content ID, we probably have built the most robust set of data. If you talk to the engineers about the quality of the incoming data sets, it's very far from perfect. So one is just there's been a lot of advancements in digital databases that isn't necessarily the perfect match to some of these skills. And then the second piece is just incentives. So there are many entities who historically have viewed some of this information as proprietary, and I think maybe overemphasize the value of keeping some of this data proprietary, where actually would benefit everyone if some of this basic information was opened up. You could build APIs and other services and systems on top of it in a way that would benefit everyone. But I don't think that mindset is there in a broad-based way.
And just to build on the first point Katie was making, I mean, when I think about this issue, I think about it more in terms of how is it hurting in dollars. So, you have Google building its database, you have Spotify building its database, you have every service kind of either building their own database or hiring a third-party vendor to try and do that for them, or relying on their database or clearing rights. That is think of the amount of money and effort that is going into doing all of that, that could otherwise, if you had something authoritative, be going toward marketing those services, paying creators, everything that would make the services and the industry more healthy. So there's a lot of money that's just falling through, if you look at a P&L, falling through, it's just being wasted, that otherwise could be put to much better use.
And if I was wearing a product manager's hat, I mean, that's a huge benefit to the first to market, to the largest players. If I'm wearing my policy hat, I'd say that's terrible. It's not, does not encourage competition from smaller service providers.
I think from the publishing side, we'd agree absolutely there needs to be a robust database. To Chris's question of why it's a lot more complicated than the sound recording side. Sound recording, you have one owner, that's clear. There's multiple owners on works, right? And they often contradict each other on what their shares are. Yeah. And that's where we talk about, Katie mentions proprietary databases. There shouldn't be proprietary databases. There needs to be authoritative database. Absolutely. The question is who's creating the authoritative. A lot of the work that the PROs do is trying to create that authoritative database. Now, and there are conversations about the PROs getting together and sharing that data and reconciling. And we do that. That's gone on for history, we'll get in rights work that from multiple publishers that contradict each other, and some of it might be represented at ASCAP. We'll reach out and say, what are you saying? How is this? Let's work this out together so we have consistent data. I think it's now taking it to that next level, making sure it's complete, not just the ASCAP BMI, and making that accessible and available. And we're bullish that that'll happen.
Yeah,
Larry,
still
I wanna-
in this, so one, copyright law is on the publisher's side. So if the publishers had a database and they said, look, whoever contracts with us among the authors, we're going to give you the proceeds, and you have a duty to account.
Yeah.
Because that is the copyright scheme. And I'm not sure why the publishers think they're going to be holding the liability ball at the end of the day.
Somebody has to play referee, if you will.
Yeah.
and I think that's what we're getting at. It's like, who's the referee on this?
Federal
And that,
district court.
So we've got just a couple of minutes left. We will have time, I think, for one or two questions. So if you do have a burning question, please step up to the mic. And as we're getting ready for that, let me just ask Steve, I think, to comment on the public performance issue for terrestrial radio and what prospects we think that may have to pass or not
Well,
in our lifetimes.
So I think it's, from our perspective, and I think it's shared in a lot of people in this room, and it was in the Copyright Office report and has been a recommendation of the Copyright Office for many years, that really there is no justification for terrestrial radio not to pay or to have an exemption from paying sound recording copyright owners. And it's...
Except we don't.
Except that we don't.
It's a
And-
justification, but go ahead.
Well, we can talk about that. But the politics are obviously very difficult. I mean, as they always have been. So it's hard to answer the second part of your question, but certainly something that we would like to see changed, obviously.
This is Bill Rosenblatt. Bill?
Oh, hi. Thanks. So here's my question. You were talking about environments that don't involve regulatory oversight of royalty rates. I can think of one, book publishing. Now, there is an antitrust component, as you know, but nobody in Washington is sitting there deciding on royalty rates for authors. And if you look at revenues, they're pretty much flat, like recorded music revenues have been flat over the past several years. And so I'm wondering if any of the panelists have any insights that could be drawn from looking at those two industries, one of which is regulated with respect to royalties and the other is not.
I would say, there is, I think, one difference in terms of the consumer behavior that we've seen. So I do think as a practical piece, users today, because of where services have developed, do have an expectation or a desire for a full service that has access to, a universal set of music.
Well, there's
What is
there are
that?
bigger differences than that. First of all, books are sold individually and they're priced individually. It is a question whether, if you really want to think outside the box in industry structure, whether streaming starts moving to having a thing where it's not a subscription model and you pay per play as a consumer, and then you'd start saying, okay, these guys charge us higher royalties, so guess what, consumer, you're going to pay more. I think there are lots of reasons the industry doesn't want to do that, but that price signal is there in with books, and it's not there today with music. It was there if you're buying, when you're buying vinyl or CDs.
or downloads.
And downloads, well, except
Some
the industry's moved
limited
away
degree
from
of
it.
basic
Yeah,
needs, before
yeah.
downloads started.
But it could be there.
Yeah.
But anyway, that's just a hugely different structure.
Well, but there have been subscription services in ebooks now recently, and we'll see what happens with their popularity, but that model is out there.
I think it just does go back to the way the two are consumed. When I'm generally not reading 10 books at once. I'm reading one book at a time, and then I move on to the next book, and I'm thinking, about, okay, and then I'll go buy that next book, or even if it were part of a subscription service, it's a one at a time kind of thing, whereas, the way on streaming at least, music is consumed is very different than that. Now, that doesn't mean one has to be regulated and one doesn't.
Yeah, and this expectation that a service has the entire recorded output of mankind is, why why is that a given right? You know,
I don't think
why-
anyone's saying it's a given right. You could certainly scale back. I'm just saying from a product user perspective, it's going to be tough for us to sell a product next year that has less music content available than last year.
Yeah,
you
from
know?
an antitrust perspective, if you want to understand the market power of a PRO or a publisher, you take Spotify as a given, just to use Spotify as an example. They want to be comprehensive. And so they have a certain position. They need those licenses, not just from one, but from all.
Well, if they need or want to be comprehensive. Yeah, I
But it's the
appreciate,
same in book publishing. You know, one reason why subscription services haven't taken off that much is because the big 5 major publishers haven't all agreed to license. Only 1 or 2 of them do.
Yeah, I mean, need or
It's a
want
chicken and
isn't
egg
the
sort of.
question. The question is, given Spotify's business realities, what pricing power does that give their counterparty in a negotiation? And from their perspective, the service is a lot more valuable to consumers if it's comprehensive than if it's not. And so this gives their counterparties more pricing power. And from the antitrust perspective, that's the question, not rights or need or want.
We only have about 30 seconds left, and I have a closing question for Chris Springman. Chris, does it matter if Led Zeppelin stole Stairway to Heaven?
It might matter in court. My only point is I'm not sure it matters artistically. I mean, it's a great song, and it's going to remain a great song.
Fair enough. Let's thank the panelists.